Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. David Vaughn decided November 26, 2024. Troutman, J. Whether to admit expert testimony concerning the factors that affect the reliability of eyewitness identifications rests within the discretion of the trial court, which balances the probative value of the proffered testimony against the prospect of trial delay, undue prejudice to the opposing party, confusing the issues or misleading the jury. People v. Primo, see People v. McCulloch, People v. Lee. The presence of evidence that corroborates the eyewitness identification is not a determinative factor in deciding an application to admit this sort of expert testimony, nor is it the first part of a rigid two-step process, see McCulloch. To the extent our holding in People v. Legrand has been misinterpreted to suggest there is such a two-step process, those cases should not be followed, see for example People v. Santiago. Here, although the appellate division referenced an incorrect framework, we nevertheless hold that Supreme Court did not abuse its discretion in granting defendants oral, mid-trial application only in part and limiting the testimony of defendants expert to the topic of cross-race effect. Therefore, we affirm the appellate division's order. 1. On May 9, 2016, two men entered a Brooklyn warehouse during working hours, one of them displaying a badge on a lanyard that he wore over a plain, brown sweatshirt. Inside the warehouse, the men were shown to an office. The man with the badge entered the office, closed the door, and drew a firearm, while the other men remained outside the door. The gunman, a black man, forced a victim, an Asian man, to surrender $3,000 cash, and the robbers left. That victim and a second victim, who is also Asian, separately called 911 as they exited the warehouse, and for a time they pursued the fleeing robbers through the streets. Surveillance footage depicts the robbery essentially in its entirety, as well as the robbers' entry into and exit from the warehouse. Although the footage is of fairly good quality, the quality is not so good that the robbers' facial features can be clearly discerned. 4 days later, the first victim was standing at a loading dock when he saw a defendant and another man walk by. The victim recognized those men as the robbers, noting that they were wearing the same clothes that the robbers wore during the robbery. In defendant's case, he wore a plain, brown hooded sweatshirt. The victim would later testify at trial that he and defendant locked eyes, and then defendant put his hood up. The victim hailed a passing police car and guided the officers down the path that the robbers took during their earlier flight from the warehouse. Shortly thereafter, the victim spotted defendant and his companion and identified them as the robbers. Defendant was arrested and brought to the precinct, where the sweatshirt was photographed inside out, vouchered, and placed in an evidence bag. By the time of trial, the sweatshirt, which had been wet from the rain when bagged, was destroyed by mold. Defendant was charged with, inter alia, robbery in the first degree, Penal Law Section 160.15, and the matter proceeded to a jury trial. After the parties finished selecting a jury, they delivered their opening statements, and the people called their first two witnesses before the court adjourned for a holiday weekend. Testimony resumed 5 days later. On the morning of the sixth day, the court put on record that defense counsel called Chambers late on the day the court adjourned for the holiday weekend and stated that he intended to call an expert to testify about cross-race effect. Defense counsel confirmed this and added that the parties received an email from Chambers, approximately 2 weeks before trial commenced, asking if the defense intended to present expert testimony on cross-race effect. Defense counsel had responded to the court's email by stating that he may intend to do so. Defense counsel then stated, for the first time, his intention to elicit expert testimony not only on cross-race effect, but also on several other factors that affect the reliability of eyewitness identification, such as the reliability of sharp identification procedures, the effect of stress, weapon focus, the duration of the encounter, distance and lighting, the use of disguises, and memory decay. Asked by the court for something in writing, defense counsel acknowledged that he had nothing prepared. The court stated that it was important for defense counsel to identify all the factors on which he intended to present testimony because there may be legal authority establishing whether they are generally accepted in the scientific community, obviating the need for a Frye hearing to determine that issue. See generally Frye v. United States. The court recognized that the general acceptance of cross-race effect had been established in People v. Boone and asked if defense counsel had case law supporting the general acceptance of the additional factors about which he sought to elicit expert testimony. Defense counsel did not have any case law to provide but offered to list the factors and supply case law later, prompting the court to admonish him for arriving late. "This is why I asked everybody to be here at 10:30 this morning because I knew this was an outstanding matter and we would be spending some time on it. Now, it's after 11 o'clock. Defense counsel apologized and listed a total of 11 factors for the court's consideration, the 8 listed previously plus the influence of private actors, the effect of multiple perpetrators, and the correlation between confidence and accuracy. The court again emphasized to defense counsel the importance of providing case law and, referring to Boone, opined that the additional factors such as the effect of stress and weapon focus were within the ken of an average juror. Thus, the court indicated that it would likely not allow testimony as to those factors unless defense counsel provided case law to the contrary. The people asked the court to preclude the expert testimony on the ground that defendant's application was untimely, but at that point the court stated that it was not likely to deny the application on that ground. The people further argued that the expert testimony should be excluded because the identification was corroborated by the surveillance video in clothing. Defense counsel argued that the jury could not conclude that defendant was the culprit based on the video in clothing alone and that the expert testimony would be informative for a jury, and he asked at least for testimony on cross-race effect. The court chided defense counsel for failing to make a motion in limine. "This case is a year old. This has never been raised before. We could have had a hearing on this. I could have had both sides brief this issue and, here we are, with a jury in the back, in the middle of trial, and you are, telling me that you want to call this expert witness. You were in front of me at least 2 weeks ago, 10 days ago. It could have been brought up before we ever picked a jury. We would have delayed on picking the jury. I would have seen this as a very significant issue." Testimony resumed, and at the end of the day the court issued a preliminary ruling that it was not likely to permit testimony on any factor other than cross-race effect. The court stated that it had read several cases and that it had discretion to admit or exclude the testimony because the identification was corroborated by the clothing and video. The court added, "The other issue is, you really needed to raise this issue a while ago, and perhaps it might have been a different result. But getting this information in the middle of the people's case that you're calling a witness, we're doing a lot of catch-up here." The court stated that it could have denied defendant's application in its entirety but explained that it was important to afford defendant the opportunity to put on a defense. Trial proceeded. Defendant neither renewed his application nor supplied case law to support it. The court adhered to its preliminary ruling, and defendant's expert testified about cross-race effect. The jury found defendant guilty, and the court sentenced him as a persistent felony offender to an indeterminate prison term of 20 years to life. The appellate division affirmed, concluding that the people presented sufficient corroborating evidence connecting the defendant to the crime to obviate the need for the additional inquiry required by People v. Legrand, and that under the circumstances of this case, the court providently exercised its discretion in limiting the testimony. A judge of this court granted leave to appeal. 2. The single greatest cause of wrongful conviction is mistaken eyewitness identification, Boone, 30 NY3D at 527. Although eyewitness identifications are often reliable, see Young v. Conway, Boone, Garcia, J., concurring, the prevalence of eyewitness misidentifications, the danger they pose to the truth-seeking function and integrity of our justice system, and the need to mitigate that danger are so beyond dispute and so well established, in New York State and elsewhere, that we hardly need to discuss the matter further. Boone. Situational and environmental factors that affect the reliability of eyewitness identifications have been the subject of scientific study for decades, and defendants in criminal proceedings, likewise for decades, have sought to present the testimony of experts in the scientific data concerning certain factors involved in perception and memory, People v. Mooney, 1990, K. J. Dissenting, C. Legrand. We have repeatedly encouraged the trial courts to admit this sort of expert testimony in appropriate cases, Santiago, quoting People v. Drake. Questions of the admissibility and scope of expert testimony concerning the factors that affect the reliability of eyewitness identifications in a particular case are addressed to the trial court's sound discretion, see People v. Barry, People v. Abney, see also People v. Cronin. Courts deciding those questions apply traditional evidentiary principles, see McCulloch, which require the courts to weigh the testimony's probative value against its prospect of causing undue prejudice to the opposing party, confusing the issues, misleading the jury, or unduly delaying trial, see People v. Perdue, McCulloch. On an application to admit expert testimony of this sort, the trial court may need to determine whether the expert testimony is beyond the ken of the average juror or generally accepted in the scientific community, see Lee. Indeed, in Abney, we reversed and ordered a new trial where the trial court abused its discretion in denying an application to present expert testimony on several factors, concluding that the court should have held a Frye hearing to resolve the issue of general acceptance, see Abney. While general acceptance may be established at a Frye hearing, a hearing is not necessary in all cases, see People v. Wesley. General acceptance may be established through legal precedent, see Matter of Leahy v. Kelly, Boone, considering lower court opinions to support the conclusion that cross-race effect is generally accepted in the scientific community, People v. Williams, holding that the court abused its discretion as a matter of law in admitting DNA evidence without a Frye hearing because the cases on which the court relied did not adequately assess whether the evidence was generally accepted in the scientific community. Where the defendant fails to demonstrate that a topic of the proffered expert testimony is generally accepted in the relevant scientific community, the trial court should exclude or limit the testimony as appropriate, see Barry. Courts must not decide whether evidence is admissible based solely on the existence or strength of corroborating evidence, see People v. Odd1, see also Holmes v. South Carolina. Nor should courts require adequate corroborating evidence as a prerequisite to weighing other considerations pertinent to admissibility, see McCulloch. Rather, courts should be guided by whether the proffered expert testimony would aid a lay jury in reaching a verdict, Lee, see Abney. Our decision in People v. Legrand does not say otherwise. In that case, we held that the court abused its discretion in excluding testimony concerning three factors that affect the reliability of eyewitness identification: the correlation between confidence and accuracy, the effect of post-event information, and confidence malleability, see McCulloch. In so holding, we observed that the prerequisites for the admission of scientific evidence were satisfied, i.e., the testimony concerning the three factors was relevant to assessing the accuracy of the eyewitness identification in that particular case. The testimony was based on principles that are generally accepted within the relevant scientific community. The testimony was proffered by a qualified expert, and the topic of the testimony was beyond the ken of the average juror, Legrand. Although we also considered that there was little or no corroborating evidence connecting the defendant to the crime, the main issue in Legrand did not involve corroboration at all, but instead concerned whether the defendant had established at the Frye hearing that the testimony was generally accepted in the scientific community. To be clear, the considerations enumerated in Legrand do not displace the traditional principles under which courts weigh the probative value of the testimony against the prospect of delay, prejudice, or confusion, see McCulloch. Courts should not apply any two-step process that references corroboration or credibility as gateway factors for the exercise of discretion by the trial court. 3. Here, the court did not abuse its discretion in granting defendant's application only in part and limiting the expert testimony to the topic of cross-race effect. The record establishes that the court reached its determination by weighing the probative value of the testimony against, among other things, the prospect of unduly delaying trial, see Perdue. On the morning of the third day of testimony, for the first time, defendant sought a ruling allowing expert testimony on cross-race effect and 10 additional factors that affect the reliability of eyewitness identifications. Although the court was familiar with the law concerning cross-race effect from our then recent decision in Boone, the same cannot be said for the rest of the factors. Defendant failed to provide a written application or legal memorandum at the court's request or cite case law to satisfy the prerequisites for the admission of scientific testimony. Even after the court made its preliminary ruling, defendant had the opportunity to renew his application, supplement it with legal support, or narrow it to some of the more relevant or legally supportable topics, see ABNY. Defendant may have dispelled the court's stated concerns at least with respect to some of the factors if he had responded to the court's direct request for case law supporting his position. For example, our precedent establishes that the correlation between confidence and accuracy is generally accepted in the relevant scientific community and beyond the ken of the average juror, both of which are necessary to demonstrate the testimony's admissibility, see Legrand. Defendant did none of these things. We cannot conclude that a court abused its discretion in excluding or limiting expert testimony of this sort on such a perfunctory application brought at this juncture of the proceedings, see Santiago, reversing where defendant moved before trial and renewed motion after a different justice was assigned to the case, ABNY, reversing where defendant moved before jury selection, the court denied as premature with leave to renew, and defendant renewed motion after the people rested, Legrand, reversing where defendant moved prior to retrial. Indeed, the cases where we have reversed illustrate the importance of a timely motion because admissibility in those cases hinged in part on the outcome of a FRI hearing that the court was able to hold before trial, see Legrand, should have held, see ABNY, or may have found necessary to hold, see Santiago. Of course, the timing of the motion is not dispositive, and indeed is less crucial, if the defendant establishes that a FRI hearing is unnecessary under precedent recognizing that the proposed testimony is generally accepted in the scientific community, see Leahy, but defendant made no attempt to do so here. Even on appeal, defendant makes no attempt to demonstrate that all or even most of the factors concerning which he sought to elicit expert testimony satisfy FRI's general acceptance standard. Defendant now focuses on three factors that he perceives to be most easily established as the subject of admissible expert testimony: the effect of stress, weapon focus, and the correlation between confidence and accuracy. Our dissenting colleague does the same. By focusing now on the most legally supportable factors and providing support for their admissibility, defendant does what he could and perhaps should have done in the trial court. His failure to have done so in the face of the trial court's stated concerns and direct request for case law is precisely the problem here. Thus, contrary to the dissent, defendant fails even on appeal to obviate the need to conduct a FRI hearing for the trial court to rule on the entirety of the application. Moreover, although our dissenting colleague would expect the court first to hear from counsel on the cause and potential length of any delay, we presume that this judge was aware of the anticipated length of delay a mid-trial FRI hearing would create. The court expressed that it understood the importance of the issue and that it was sensitive to defendant's right to present a defense. The court also expressed that it would have been amenable to delaying trial for a FRI hearing and a full briefing had defendant made his application prior to jury selection. In the end, the court exercised its discretion by granting defendant's application in part and limiting the expert's testimony to the topic of cross-race effect. We emphasize that the timing of the application and the prospect of trial delay are not dispositive considerations. The court could have delayed the jury trial and held the FRI hearing or granted the application in its entirety if defendant had been able to establish that a FRI hearing was not required. Under the circumstances, however, especially given defense counsel's failure to submit a written application supported by legal authority despite the court's request for that information, we cannot say that there was an abuse of discretion in the court's balancing of the proffered testimony's probative value against the prospect of causing undue prejudice, confusing the issues, misleading the jury, or unduly delaying the proceedings. Accordingly, the order of the appellate division should be affirmed. Order affirmed. Opinion by Judge Troutman. Chief Judge Wilson and Judges Garcia, Singas, Canataro and Halligan concur. Judge Rivera dissents in an opinion. Decided November 26, 2024.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law